For any of your clients out there that are watching this that don't have an estate plan, which includes a trust, will, powers of attorney, I can't stress enough how important it is to get on it.
Hey there, Angel. How are you?
I'm good. Good morning, Joe. Thanks for having me again.
Let me introduce you to all of our folks here on social media, YouTube, everywhere. Angel Riley, you're a local attorney here with Chauvel and Glatt in San Mateo. Can you kind of tell us a little bit about yourself again? Give us a quick bio.
As Joe said, my name is Angel, and I'm an attorney with Chauvel Glatt. I specialize and mainly focus on estate planning, trust admin, and probate. As Joe contacted me last week, one of our topics, or the topic of today, is Prop 19. It's a very eager topic amongst my clients, and I kind of geek out talking about it because it's what I do, and I enjoy working with my clients. That's pretty much what I do at Chauvel Glatt.
Okay, perfect. So I'm glad you mentioned Prop 19. So I'm just going to bring up what we talked about a little bit, is that there's a couple of components to Prop 19. One is, as people know, is that it expands the property tax transfer. If you're over 55 plus, Prop 60 basically extends it to the state. We're not going to talk about that today. What we're going to talk about today is the other component of it, which is transferring over the property tax from parent to child through death, things like that. I'll let you kind of take it from there. Tell us about that. What are high level, summarize it, please.
Yeah. So Prop 19, first of all, and before I go into sort of the legal aspect of it, just a little disclaimer out there for all your viewers. The information that I discussed today, it's not meant to be legal advice, and it's not fact specific. So, families and situations differ. So obviously, if this is something that you think pertains to your family and that your family may be affected by Prop 19, please do speak to your CPA, your legal counsel, and people in this profession that can advise you down the right route. And at the same time, with the ever-changing situation, whether it's on Capitol Hill or, on our current state ballot, the laws change. And so the information that I'm discussing today is really what we know as of today. Going off of that, Prop 19, effective February 2021, so next year, coming up very soon for a lot of my clients that want to, kind of explore legal avenues to mitigate or to plan around Prop 19. Basically, and what I'll do is I'll start with kind of the laws regarding parent-child transfers now, and then I'll talk about what Prop 19 does to basically reverse what's in place right now. So today, right, and for the last, I think, quite a few decades, if there's a parent-child transfer, and when I say parent-child transfer, that could be gifting during lifetime, or that could be gifting via default of death, when a parent dies and the property naturally goes over or transfers over to the child via probate or trust administration. Currently, and still the law before February 2021, parent-child transfers of the primary residence is completely exempt from property tax reassessment. So the way the law works is that doesn't matter if you have a home in Atherton or maybe a small condo in Daly City. If it's a parent-child transfer of a primary residence, we don't care what the market value is. We don't care what the assessed value is. Parent-child transfer is completely exempt from property tax reassessment. In addition, the current law, and again, still in effect until February of 2021, if the parent owns a investment property, or let's say multiple investment properties, and it could be commercial, it could be vacation homes, Airbnbs, rentals, the exemption allowed for the parent-child transfer is up to $1 million assessed value, not market, assessed, right? So for instance, if the parents have a, let's say, rental home in Palo Alto that they bought maybe in the 60s for, I don't know, $60,000, right? The assessed value is probably around that, or maybe no more than 100,000, let's just say, for my example. And so under that $1 million assessed exemption, the parent can still transfer to the child that additional investment property free of property tax reassessment. Why? Because the assessed value falls under the $1 million exemption. And so if you think about it, a lot of our clients that have multiple investment properties, so long as that assessed value, the combined assessed value falls under the $1 million per person or per donor exemption, parent-child transfers are completely exempt from property tax reassessment. Now, what did Prop 19 do? So Prop 19, first of all, it completely gets rid of the $1 million assessed exemption for any investment property. So now going forward after February of 2021, if a parent transfers to a child investment property, we don't care if it's Airbnb, commercial, rental, we don't care. We don't care if it's under rent control, it doesn't matter. Parent-child transfer of any investment property will be reassessed at full market value. And then in terms of the primary residence, Prop 19 also altered that exemption quite a bit, okay? And what Prop 19 did is after February of next year, if a parent transfers either through gifting, even selling, or through death, a primary residence, the child, in order to receive any kind of property tax exemption, they have to, one, live in the residence. The child has to live in the residence. The child has to move in.
It has to make it from primary residence to now the child's primary residence for that to qualify. Okay.
Yep. And even when the child moves into that residence, the exemption is now capped at $1 million market value. Another hypothetical, let's say, the parent has a home, we'll just say in Millbrae. Property's worth $2 million, which is pretty standard, right? Yes. The child moves in and the child gets $1 million market value discount. So at a minimum, and in theory, they could be assessed for the additional or for the remainder of that million. So if you do the math on $1 million property, 1.2%, it's a big bill compared to what the parents were paying when they bought the property, from the 60s or 70s. Those two changes are the major changes in terms of transfers between parent and child under Proposition 19. And again, Proposition 19 goes into effect. I'm telling everybody February of 2021, and because my cutoff for my clients is around January 20th of 2021. So I'm telling them, if you want to do something about this, we do it now. We don't wait until the end of January. We don't wait until the beginning of February, because you can assume that counties are going to be likely bombarded with deeds or various transfers, try to get around Proposition 19.
Perfect segue into one of my main questions is, number one, what can people do? You're saying that they have to meet with you or, by January so that they can take action and do something to avoid any issues. Number one, what can they do? And number two, just want to make it clear, I do not see this as legal advice.
So there's multiple things clients can do. And, kind of the nature of anything that we do in this country to bypass any kind of taxes, right? When you do one thing, you trigger something else. There's never like a free for all, even with 1031 exchanges down the line, someone's going to pay taxes, right? If it's not today, it's down the line. When Prop 19 passed, even before it passed, I made calls to other attorneys in this area, estate planning attorneys who've been around much longer than I have, and just kind of anticipate, if this passed, what are you going to do? What's in your toolbox? And one of the biggest problems is anytime a proposition is passed, even the admin offices, which would be your assessor's office in every county, right? They don't receive sort of their handbook. They don't receive their admin guidance until the legislatures meet in office. And I'm told that, that information is going to be trickled down to assessors sometime in maybe mid-January. That's our estimation. Now, obviously, we can't wait till mid-January to act, right? And so a lot of us, at least for me, I'm sort of reaching into my usual and trusted toolbox that I already had before Prop 19 and utilizing the rules that I'm already familiar with to combat this particular new rule. I'm not creating anything new. And the reason why I'm not doing that is because we have yet to see how assessors' offices are going to administer this new Proposition 19. And so in looking at my toolbox, there's sort of like four ways that, or 4 avenues clients have to think about to, decide if they want to do something to prepare for Proposition 19. The first one is obviously you can give property to your child now. Okay, you can give property now. And one of the things I've been telling clients is, if you own your primary residence, at least, I mean, if it was me, even if I had a child, I would be a little bit hesitant deeding 100% interest to my child, right? Because for multiple reasons. What if something goes bad and my child decides to, refinance without my knowledge, decides sell the home underneath me, or maybe it's not, those, sort of malicious moves. What if the child, gets into a lawsuit and that home is subject to litigation, right? So all these things that make parents think maybe I don't want to do that. And so one thing that you can do to kind of get around that is if you want to deed, let's say 90% interest or 95% interest to your child so that the parent still retains 5% in interest. It's not a protection in all those aspects, but it does leave the parent with some level of control. That's option one. I'll talk about the pros first, and then I'll go into the cons. So in all these options that I'm discussing, the pro is obviously, you get to utilize your parent-child exclusion as it's still available to you now before Prop 19 goes into effect February of next year. So in doing that, option one, you can give property out now. Option two, you can give property to a child now, but instead of giving them a majority interest, you give them 50% interest through a tenants in common, and then subsequently a joint tenancy with right of survivorship transfer. The reason why is because California has different sort of what I consider quirky rules that they don't categorize as change in ownership. One of them being joint tenancy. And the way that works is, because joint tenancy, you have normally 2 people, right? And so let's just say for an easy example, you have mom and kid. When the first tenant dies, by default of joint tenancy, the other surviving tenant receives the property. That's called the right of survivorship. In California, if the surviving tenant receiving 100% interest in the property is an original transferor, they don't consider that as change in ownership, a quirky rule. So you can utilize that.
Original transfer, that means that they bought it at the same time, or they were both originally on title, or that second person joint tenant could have been added at any time in 40 years.
Both. So the first one works. The second one, what you would essentially have to do right now is the parent would have to, and for me, that's how I would do it to keep it clean. Transfer 50% interest in the property to the child first as tenants in common. And then collectively, 50%, 50%, the parent and child would then issue or file another deed, simply transferring the property or changing the titleship from tenants in common to joint tenancy with right of survivorship. So that when you look back on the deed, right, parent and child are the original transferors. And the third way is the LLC or legal entity route. And for that, it's also, playing on again, what I call a California quirky, property tax rule, whereby if you have property in a legal entity and less than 50% of it is transferred to anybody, that is not considered a change in ownership. So if you play on that, what you would do is if you're a parent, you would transfer 51% of your property to a child. And then collectively, the parents' 49% and the child's 51% would go into an LLC. And they would manage it and live their lives for the next few decades, what have you. And then when the parent dies, assuming the parent dies first, 49% transfers the child. And because it's less than 50%, there is no change in ownership. And if there is no change in ownership, you can't get reassessed.
Unless California adds little stipulations down the line eventually to...
Well, of course, yeah, other propositions. And, of course, as they come and as they get voted in, we'll just navigate to that as we're doing now.
Right. You said LLC, is that include a trust? Is a trust a legal entity? It works the same way, or is that?
No.
Okay.
No, only legal. Now, a trust can be a member of an LLC, but ultimately the property has to be sort of sheltered under this LLC branch, which, in speaking with a lot of my clients, if you have investment property, that's not a bad idea because you're sheltering against limited liability, or you're sheltering it with limited liability anyway. Not a bad plan. Now, these three options, I said, the pro is you get to, utilize these three avenues to possibly combat, Prop 19. The con, and it's a pretty big con, is the capital gains or the basis in the property that the parent wants to transfer to a child. And explaining this, I'll just use the first option that I gave to keep it simple. So you and I probably know that when it comes to basis, when I say basis, what I mean is the value of your property as the IRS knows it, not property taxes, but the IRS, right? So for any normal family, let's just say, again, my Palo Alto example, mom and dad bought the property in the 50s and 60s in Palo Alto for 60 grand, okay? Their basis per the IRS is 60 grand. And so the way the basis works is if mom and dad sell the property today, and let's say the property is worth, I don't know, 3 million, from 50 or 60 grand to 3 million, there's a whole chunk of gains. And gains is considered income. And so they're going to have to pay Uncle Sam, in my hypothetical, hundreds of thousands of dollars. When you gift property, you also gift your basis. And so in example one of the options that I discussed, if the parent in Palo Alto gifts to the child the home in Palo Alto, well, yeah, sure, you get to utilize your property tax reassessment as we still have it now. However, the child also receives the parent's basis, which is a low $50,000, $60,000, right? The problem with that is, okay, the child receives the property, now this month or next month. If the child decides to sell the property, let's say in 20 years or 30 years, and the child's basis is still 50,000, 50, 60,000, and now the property now in 20 years is worth, I don't know, 6 million, that child has this huge capital gain. And again, you're paying Uncle Sam hundreds of thousands of dollars. And any CPA would tell the parent, do not gift. Because if the consequence of that is hundreds of thousands of dollars, you're paying decades of property taxes to make up for that, right? So it's almost like you might as well just take the property tax hit and not give up your capital gains or give up the basis, right? So that's the big con in the three options that I discussed, and so it's quite a dilemma with my clients because, most of my clients are parents, right? They're instinctively programmed to want to take care of the child and to protect. And one of the things that I sort of hammer into them is talk to your child, because what if they just want to cash out? What if they don't want to own property? What if they don't want to live in Palo Alto? What if they don't want to be a landlord and all they want is the cash? Then just leave things be, right? Because when you pass away, yeah, they're going to get hit with, the reassessment, but they're also going to, hire somebody like you to sell. And when they sell, the property at the death of a parent is fully stepped up. And so you're mitigating then having to pay the heavy capital gains tax. Now, the fourth option, which, is something that I'm newly exploring, and it's really just to combat the issue with capital gains, is an irrevocable trust. Parents can set up an irrevocable trust where the beneficiary is the child, transferring the property into an irrevocable trust while maintaining what we call a power of appointment. The reason why this works is because once you transfer something into an irrevocable trust, it's a change in ownership as far as the county is concerned. In terms of the IRS, if a parent or anybody retains a power of appointment in a trust, they consider that to still be part of your estate. And if it's still part of your estate, then you can possibly still get a step up in basis. On the issue of just the federal government and taxes, we're all kind of anxiously waiting for January and February. I can almost guarantee that if the Senate is flipped, we are going to see some changes in taxes. And in my world, I'm not talking about income tax. I'm talking about the federal estate tax exemption. And there's rumors that, Joe Biden may get rid of the capital gain step up in basis. I find that to be more remote, but it's not impossible. A lot of things that we're doing now, obviously we have, in terms of the state, we have the February cutoff to, combat Prop 19. And then once a transition is made in the White House, we have also until spring and summer to kind of really keep in touch with the news and what's happening in terms of the federal laws and taxes.
My takeaway from this is that somebody who has these questions really has to sit down with someone like you, preferably you, and who will sit down and just go over all the scenarios and their specific situation and what they want to do, what their kids want to do, and how much their properties are worth and all this kind of stuff, and just make sure that they make the right decision for them and their family. And they need to get on it ASAP, even if they're like, hey, you know what? I don't care about the reassessment. I want to pay that. I don't care about the capital gains. I want to pay that. Great. They should at least know what they're getting into and just plan, because it doesn't hurt, right?
Yeah, absolutely. And, for any of your clients out there that are watching this that don't have an estate plan, which includes a trust, will, and powers of attorney, I can't stress enough how important it is to get on it. It's important to plan for the future. And, frankly, if you don't do it, you're leaving quite a emotional mess for your heirs, whether it's children or siblings or parents, or what have you, So
We both know how that goes with our probates.
yes, we do. Yes, we do. Yeah. And luckily they have you to guide them through the real estate
And
sales.
you,
Yeah.
everything. What's the best way to reach you and get in touch with you?
Yes, the best way to reach me, if you're an email person, you can email me, angel@chauvellaw.com, and Chauvel Law is CHAUVELLAW.com. If you're a phone kind of person, 650-573-9500.
Fantastic. So that's all I got. So thank you so much, Angel, for joining us, and really appreciate it. And we'll have your contact info in the description, and looking forward to our next topic.
So it's been nice. And I hope you and your viewers have a happy holidays, and please stay safe.
Thank you. Thank you. You too.